Thank you, Rob. Is it okay if I stand over here? It looks like that's occupied. It's being filmed, right? Do I need to be back there? Or? Okay, good. Well, I'm very grateful to Professor Coons and to the Phi Beta Kappa chapter, the Alpha Chapter Texas, for the honor of participating in this wonderful lecture series. I want to say a word of encouragement to students who are here. I hope that you'll aspire to membership in Phi Beta Kappa, and if and when you have the good fortune of being elected, I hope that you will accept the invitation to join. It's a wonderful organization. If you are elected to Phi Beta Kappa, that's a sign of remarkable achievement, distinguished achievement in the arts and sciences. And if you become a member and choose to participate, you'll be helping to maintain the high standards that Phi Beta Kappa has always stood for in the arts and sciences. And those are standards that really need to be maintained and defended. So I very strongly encourage you to spot a membership, and if you are elected, to join the organization. Well, we hear a great deal today about deficiencies of civic knowledge among young people. Surveys reveal that many high school and even college students know very little indeed about the American founding, the Civil War, and other great events in our national history. However, I must say that I cannot speak about that from personal experience. My own students seem to know quite a lot. They can, for example, identify not only the century, but even the decade within the century in which the Civil War was fought. Even before arriving at Princeton, they know that Lee surrendered to Grant, not to Eisenhower, at Appomattox Courthouse. And apparently that's something of an achievement, because the pollsters tell us that a substantial percentage of our young people don't know which way to guess on the Grant versus Eisenhower question. Most of my students know that it was Philadelphia and not Washington, D.C. that played host to the Constitutional Convention. Few would list Alexander Hamilton among our nation's most important presidents because they know he was never president. Some can even identify the cabinet office he held and tell you something about the points in dispute between Hamilton and Jefferson. Speaking of whom, all of my students know that Jefferson owned slaves, but then everybody seems to know that, even if they don't know anything else about him. My students, though, know that it was Franklin Roosevelt, and not his cousin Teddy or Harry Truman or JFK, who promised Americans a New Deal. Some can even tell you that the Supreme Court invalidated early New Deal legislation, and that the FDR responded with a plan to pack the Supreme Court. Yes, my students and students at major colleges and universities around the country, I'm sure it's true here in Texas, the university, know a great deal, come to campus knowing a great deal about American history and wanting to know more, wanting to know American history better. Many of these young men and women value historical knowledge not merely for its own sake, although that's important and good, but also because they see that kind of knowledge as valuable to their interest in being good citizens. Moreover, they seek to be not only good citizens, but genuinely of service to their fellow citizens. Many hope to be in public office, perhaps appointed, perhaps elected. Many aspire to be judges. They know that knowledge of American history is vital to effective citizenship and to the kind of service they would like to render. And it's true, historical knowledge is indeed critical, even indispensable. But when we understand why and how that is the case, we see that it requires important supplementation by the teaching of the principles of American civic life, particularly the principles of the Declaration of Independence and the Constitution. Even among the most talented and best prepared entering college students, it's rare that they come to campus with anything really like a solid grasp of the philosophy of America's constitutional government. Think of a very important question, a question that we should all ask. That's the question, how did the Founding Fathers seek, via the institutions that the Constitution created, to build and maintain a regime of ordered liberty? Now, even some of our best informed students think that the answer to that question is something along these lines. Well, here's how the framers thought they could do it. They would set down a list of basic freedoms in a Bill of Rights, which an independent judiciary, protected from the vicissitudes of politics, would then enforce. That's what they thought, and that's what they gave us. It's the rare student indeed, in my experience, who enters the classroom already aware that the framers believed that the true bulwark of liberty was limited government. Few students comprehend the crucial distinction between, on the one hand, the national government as one of delegated and enumerated and therefore limited powers, and on the other, the states as governments of general jurisdiction, exercising police powers to protect public health, safety, and morals, and to advance the general welfare. If anything, they imagine it's something like the other way round. They even suppose that our system is like the British or French system, where power is vested in central government, and then it's the power of the provincial or local governments is derivative of the central power. Thus, and they even have trouble imagining how it could possibly be the other way around, and thus they have no comprehension as to why leading supporters of the Constitution objected to a Bill of Rights, worried that it would compromise the delegated powers doctrine and thus undermine the true liberty-securing principle of limited government. So in my undergraduate courses in constitutional interpretation and civil liberties, I'll very frequently begin by asking them where the Bill of Rights is in the Constitution. Hands all go up. It's in the first 8 amendments, or some students say first 10 amendments, or some students say first 10 amendments plus the 14th Amendment. Pretty good answers. Interesting. Then I ask, why isn't it in amendments? Why isn't it in the body of the Constitution as originally framed and ratified? Well, not very many hands go up then. And so I ask, did they forget to put it in the first time? Did they really not like liberty? They weren't interested in protecting liberty. They were interested in other things. Then later, perhaps grudgingly, they decided, well, let's protect some liberty. And so we launch into a conversation in which we consider why, at least in the first instance, Madison, and then certainly Hamilton, so vigorously opposed the idea of a Bill of Rights. Not because they were enemies of liberty by any means, but because they saw the Bill of Rights as potentially undermining the liberty-preserving, securing principles of the Constitution. Good students these days have heard of federalism, certainly, yet they have little appreciation of how it works or why the founders thought it so vital. They've heard of the separation of powers and often can sketch a pretty good, sketch a pretty good account of how the system of checks and balances is supposed to work. But if one asks a very important question, especially in view of the answer to the first question I often put to my students about how does the Constitution protect liberty, if one asks the question, well, in the system of checks and balances, who checks the courts? Well, there students find themselves stumped. We have a kind of interesting discussion. Is the threat of impeachment the way the courts are checked? Is it really the power of appointment and confirmation by the Senate, appointment by the, or nomination by the President and confirmation by the Senate? Is that the check? What exactly is the check? Now, the students' lack of awareness flows partly from the conception of the American civic order that they have drunk in, which treats courts as if they really aren't part of the government. Judges on this view are, quote, non-political, unquote, actors whose job is to keep politicians in line with what in certain circles are regarded as enlightened opinions. Judicial supremacy, the idea that judges have the final word, or the ultimate interpreters, final and authoritative interpreters of the Constitution, thus winds up being treated uncritically as sound constitutional law. The idea that courts themselves could violate the Constitution by, for example, usurping authority that the Constitution vests in other branches of government is off the radar screen, at least in the beginning. It won't be too long before we can get our students, if we get them focused on the question, to be thinking about that problem, the problem of judicial usurpation. Now, perhaps judicial supremacy in constitutional interpretation is sound constitutional doctrine. I don't want to rule that out of court from the beginning. Many distinguished constitutional scholars believe it. Many of our great statesmen, surely many of our jurists, have believed it and defended it. My point is not that it's wrong, although as it happens I do believe it's wrong. But it's not my point here that it's wrong, or with my students that it's wrong. And my goal is not to get it into students' heads that it's wrong so they'll agree with me. My point is that if it's true, if it's sound, if it's right, it's not self-evidently so. In fact, the point is so highly disputable that it was flatly rejected by some of our nation's greatest statesmen, including Jefferson and Lincoln. So this is an important debate in our constitutional history about the philosophy of constitutional government in this democratic republic. And it's a debate that it's important for students to enter into. It's important for them not only to know about the debate, but to be participants in the debate. To have opinions, but opinions formed on the basis of listening to what arguments the brightest, most penetrating thinkers on the competing sides of the question have to offer. According to the standard account of the matter, the power of judicial review, that is the authority of the federal judiciary to invalidate acts of Congress and the President when they are deemed to be unconstitutional, state laws as well, of course, came to be entrenched in our law by the acceptance, tacit or otherwise, of the Supreme Court's ruling in the 1803 case of Marbury against Madison. Now, of course, nowhere in the text of the Constitution is this power of judicial review explicitly granted. This generates my third question to my class at the beginning each year. This power of judicial review, this method by which the founding fathers, students suppose, protected liberty, entrenching a Bill of Rights in the Constitution and empowering an unelected and electorally immunized judiciary to enforce. This great power, where does one find it in the Constitution? The Constitution, after all, lays out the powers of the different branches of government. Got the legislative power laid out there and the terms of the powers conferred upon the Congress, and we have the executive power laid out, and then in the third article we have the judicial power. Well, students will say, well, this power is in the third article of the Constitution because that's the article conferring and distributing the judicial power. All right, fine. Where in Article 3? And then they get out their magnifying glasses and they look to see where the courts are granted this power, and of course, they can't find it because it's not there, at least expressly. Rather, Chief Justice John Marshall, the great Chief Justice, in Marbury inferred the existence of that power, at least something like it, from the fact that the written Constitution declares itself to be the supreme law of the land, combined with the evident principle that, in Marshall's language, it is impactful to say what the law is, unquote. Now, a lively dispute has existed from the moment the court handed down its decision in Marbury as to the scope of that ruling. Even today, some scholars argue that it did nothing more than declare that the Supreme Court is within its rights in declining to exercise an authority putatively conferred upon it by Congress when such authority exceeds the jurisdiction granted by to the court under Article 3 of the Constitution. Now, certainly as a technical matter, all the court did in Marbury was to refuse to exercise original jurisdiction beyond what it was granted in Article 3 on the ground that the expansion of its original jurisdiction by Congress, Section 13 of the Judiciary Act of 1789, was unconstitutional. So the contemporary constitutional scholar Robert Lowry Clinton argues that it's a mistake to read the case, to read Marbury, as claiming a judicial power to tell the President or Congress what they can do or not do under the Constitution. Clinton maintains that it simply stands for the power of the court as a co-equal branch of government to act on its own interpretation of the Constitution in deciding what it can and cannot do. It can accept the original jurisdiction putatively conferred upon it by an act of Congress, arguably going beyond what is granted in the Constitution in Article 3. This, Clinton observes, is entirely consistent with the recognition of a like power in the other branches of government. Now, of course, the conventional reading of Marbury, shared by the decision's friends and foes alike, has it standing for a considerably broader scope of judicial authority. Thomas Jefferson condemned the decision precisely because he viewed it as claiming a power of the courts to impose constitutional interpretations on the executive branch and the Congress. This, Jefferson later asserted, would have the effect, and I quote, of placing us under the despotism of an oligarchy. And at the opposite extreme from Professor Clinton's reading, this narrow reading, at the opposite extreme, is the reading offered by the Supreme Court in the 1958 case of Cooper against Aaron. There, the justices presented judicial supremacy, that is, their own right to the final say on the meaning of constitutional provisions, the power to impose it on the other branches, as nothing more than a straightforward, uncontroversial, altogether mundane, logical implication of Marshall's proposition about, quote, the province and duty of the judicial department, unquote. Indeed, the paragraph in which the justices in Cooper claimed supremacy for themselves offers nothing in its support, I find this really quite remarkable, nothing in its support beyond the bare invocation of Marbury. They make the claim for themselves, cite Marbury, kaboom. Well, whatever it was Marbury was supposed to mean about the scope of the power of judicial review, it's a notable fact that the court declined to exercise that power to declare another act of Congress to be unconstitutional until 1857, when it ruled in the case of Dred Scott against Sanford. It had reviewed and struck down some state legislation, of course. But it had not struck down another federal statute in all those decades. And of course, it chose what turned out to be an extremely inopportune moment to go back into the business. Scott was a slave in Missouri who had been taken by his master into the free state of Illinois and the free Wisconsin Territory. He then brought a suit demanding his freedom in St. Louis County Court under Missouri law, claiming that he was legally entitled to be free by virtue of having resided on free soil in a free state or territory. Now, Dred Scott won the trial judgment, won in the trial court, but the ruling in his favor was then reversed by the Supreme Court of the state of Missouri. So Dred Scott then brought a new case, started up again in the federal system, to consider, among other things, whether a state could reverse the once free, always free principle under which the St. Louis County Court had originally ruled in Scott's favor. Now, once the matter entered the federal courts, it became a massive political hot potato. Sanford, whose name was actually Sanford, the D got inserted in the style of the case mistakenly, but Sanford, acting on behalf of his sister, who was Dred Scott's owner, injected into the litigation the question whether any black person, slave or free, could be a citizen of the United States, and he directly challenged the constitutionality of the Missouri Compromise. Although the power of Congress to forbid slavery in federal territories was, in many circles, widely established, Sanford argued that slaves were private property of precisely the sort protected by the Constitution against deprivation without due process of law, and therefore Congress lacked any constitutional authority to stop a slave owner from bringing his slave into as a slave and returning to a slave state with his slave. When the matter reached the Supreme Court of the United States, Chief Justice Roger Brooke Taney, writing for a 7-man majority against 2 dissenters, accepted Sanford's major contentions, not only sending Dred Scott back into slavery, but holding in effect that he had never been free. The majority ruled that blacks could not be citizens of the United States and therefore lacked the concomitant right to bring lawsuits in the federal courts. Moreover, the justices held that Congress lacked constitutional authority to forbid or abolish slavery in the federal territories, even though they had general jurisdiction there. And still further, since slaves were, the court ruled, personal property protected by the Constitution, the Missouri Compromise was unconstitutional. Well, all of this added up to a sweeping and profound ruling. The court had massively injected itself into the most divisive, morally charged issue of the day. In a book I edited a few years ago called Great Cases in Constitutional Law, there is a very interesting exchange between Professor Cass Sunstein of the University of Chicago and Professor James McPherson, my colleague at Princeton, the very distinguished Civil War historian, regarding the impact of the Dred Scott decision. Sunstein defends the commonly held view, it's a view I myself share, that the case polarized an already dangerously divided country and made the Civil War and its toll of carnage almost inevitable. Instead of ending the conflict over slavery by definitively resolving it, on some accounts what Taney was after was trying to get the slavery issue out of politics so it wouldn't be so divisive for the nation. But instead of doing that, the court, according to Sunstein, intensified the conflict and heightened emotions. Now, McPherson holds the minority view that the case did not really polarize the country any more than it was already polarized by the issue of slavery in the territories. Whichever scholar has the better argument, they agree that the decision in any event focused the debate over slavery and introduced into the already heady brew of issues involved in that debate the question of the scope of judicial power under the Constitution. McPherson points out that so thoroughly did the Dred Scott decision pervade and structure the Lincoln-Douglas debates in 1858 that in one of those debates, a Douglas supporter shouted from the audience to Lincoln, "Give us something other than Dred Scott." Quick as a cat, Lincoln responded, "Yes, no doubt you want to hear something that don't hurt." To Lincoln, Dred Scott was an abomination. But it was that for reasons going beyond even those set forth by the dissenting justices. Now, as to the moral substance of the dissenters' reasons, I never miss an opportunity to quote from the opinion of Justice McLean, who proclaimed, "A slave is not mere chattel. He bears the impress of his maker and is amenable to the laws of God and man, and he is destined to an endless existence." To which Lincoln may well have said amen. But as I say, Lincoln had additional reasons to condemn Dred Scott, or the ruling Dred Scott, not the slave, the Dred Scott ruling, reasons having to do with its expansive conception of the scope of judicial power. That Lincoln was a devoted partisan of the Declaration of Independence and viewed its statement of principles as integral to the American scheme of constitutional government is, if anything, an understatement. However, the Declaration was not the only writing of Jefferson's of which Lincoln was mindful. In Jefferson's letter of September 28, 1820 to William Jarvis, from which I quoted earlier his line about judicial despotism, Jefferson explained his opposition to judicial supremacy in constitutional interpretation as follows. Quote, "The Constitution has erected no single tribunal, knowing that to whatever hands confided with the corruption of time and party, its members would become despots. It," that being the Constitution, "has more wisely made all the departments co-equal and co-sovereign within themselves. If the legislature fails to pass laws for a census, for paying the judges and other officers of government, for establishing a militia, for naturalization as prescribed by the Constitution, or if they fail to meet in Congress, the judges cannot issue their mandamus to force them. If the president fails to provide the place of a judge, to appoint other civil and military officers, to issue requisite commissions, the judges cannot force him." Unquote. Now, I dare say that to us, living in the aftermath of an expansion of judicial power that may perhaps more properly be conceived as having been ratified rather than created by the Supreme Court in Cooper versus Aaron, this language is nearly shocking. Part of this, no doubt, has to do with the prestige that courts, including the Supreme Court of the United States, enjoy, especially in elite sectors of our culture. Criticism of the scope of judicial power is often perceived by its partisans as, in effect, attacking the independence of the judiciary or even the ideal of judicial independence. I used to be a member of the American Bar Association, perhaps some of you are, and there is a committee on judicial independence which very frequently puts out statements, often when courts are attacked for overstepping the scope of their authority, and I sometimes wonder whether that committee, in effect, treats any criticism, any questioning of judicial authority or any accusation of the courts of having usurped the authority of a competing branch as an attack on judicial independence. Now, why this should be the case is an interesting question, but let's not be detained by it just at the moment. The key thing to see is that Jefferson's language was not at all shocking to Lincoln. On the contrary, it's entirely in line with his own fears of the political consequences of judicial supremacy. Like Jefferson, Lincoln believed that courts, including the Supreme Court of the United States, could violate the Constitution and even undermine constitutional government. That judges, whenever they invalidate executive or legislative acts, purport to speak in the name of the Constitution and for the Constitution, claiming merely to be giving effects to what it commands, was, in Lincoln's view, no guarantee against judicial despotism. Judges exercising effectively unconstrained power were, in Lincoln's view, no less a threat to the Constitution than other governmental officers exercising such power. His fear was not that judges would sometimes err in their constitutional rulings. Given human fallibility, that is inevitable and unremarkable. His fear, rather, was that judges are capable of behaving anti-constitutionally, just as other officials are capable of behaving anti-constitutionally, by seizing authority granted by the Constitution to other branches of government and thereby usurping the authority of those branches. Indeed, Lincoln believed that judicial violations of the Constitution were in certain respects graver matters than violations of elected officials. After all, when an elected official oversteps, the people have recourse. They can throw the rascal out at the next election. But judges, of course, in the federal system, Article III judges, are insulated against that. The only chance would be to remove them by impeachment. Lincoln, of course, was a lawyer. He knew from experience that judges come in all shapes and sizes, competent and incompetent, conscientious and slapdash, honorable and corrupt. He wasn't a skeptic after the fashion of the legal realists who would rise to prominence in the law schools 50 years or so after his death. But his view of courts was nonetheless realistic. He knew that it was essential to the success of a lawyer to know the law. But he also knew that it didn't hurt to know the judge. He believed in courts, but he did not venerate them. Nor did he automatically identify whatever the court said with the law. His mature and most profound reflections on the scope of judicial power and the role of the judiciary in the American constitutional system came in relation to the debate over Dred Scott. By 1858, when the question was at the heart of the political contest in which he was engaged, the court had ruled, but the question of the ruling's status and bindingness and what posture the other branches should take toward it was far from resolved. Remember that this was still a new thing. It was only the second time. Marbury had been decades earlier. And there was a key difference from Marbury. There was absolutely nothing that Congress could do to reverse Marbury. The courts were just refusing to exercise jurisdiction in an area where Congress had purported to convey it, confer it. But here, Tawney and the majority were purporting, plainly, straightforwardly, to bind the other branches of government as to what they could do with respect to the question of slavery in the federal territories and with respect to the possibility of blacks being citizens. The question of the proper posture for it was very much alive then, for the proper posture for other branches to take toward it was very much alive, and a politician's position on that question might very well determine his electoral fate. Bound up as it was with the urgent and divisive issue of slavery, there was no avoiding the issue of whether Dred Scott was rightly or wrongly decided and what the other branches ought to do about it, despite the best efforts of even the most agile politicians of the day, such as Stephen Douglas, to find a way around it, make the issue go away. Upon his election as president, Lincoln faced the matter squarely in his inaugural address of March 4th, 1861. With the specter of civil war looming, the president, who had denounced Dred Scott repeatedly, again, the case Dred Scott, not the slave, had denounced the decision repeatedly in his senatorial campaign against Douglas in 1858, as well as in the presidential campaign, turned attention to that case in his remarks to the nation. Now, understandably and rightly, when we think of that first inaugural address, we tend to think of the stirring words at the beginning of the address, when he is pleading with the South not to secede, when he is plainly anguished in his petition to them not to destroy the Union. I have sworn a solemn oath to save the Union. You have sworn no oath to destroy it. It is in your hands, my dissatisfied brothers of the South, and not in mine, that the great question of civil war lies, and so forth. We remember those words. But later in the opinion, we get to words that are too often forgotten, words that go right to the heart of this question of judicial supremacy, and the nature of our constitutional system. And here, listen to what Lincoln has to say. It's really quite remarkable considered in light of what we have now pretty much come to accept as standard fare. Here's what Lincoln says. I do not forget the position assumed by some that constitutional questions are to be decided by the Supreme Court. Now, pause right there. Get that? I don't forget, assumed by some that constitutional questions are to be decided by the Supreme Court. We look back on that today, having drunk in with the daily newspaper what we expect and assume courts are empowered to do, and we say, what do you mean, assumed by some, that constitutional questions should be decided by the Supreme Court? That's the business the Supreme Court's in. That's what they do. I mean, we even hear congressmen, if you watch C-SPAN, you'll hear a congressman who's supporting a certain bill, and he'll say, this bill is going to be great for the country, and we need this legislation, and I hope my fellow members of this House will back it 100%. And then the guy from the other side comes up and says, well, I certainly am not going to back this legislation. It's unconstitutional. And then the first guy who's defending the bill says, well, it's not for us to decide. Let's pass this bill, and the courts will tell us whether it's constitutional. The assumption is it's their job. That's the business the court's in. But Lincoln says this is merely a position assumed by some. Do not forget the position assumed by some, that constitutional questions would be decided by the Supreme Court. Nor do I deny, Lincoln goes on, that such decisions must be binding in any case upon the parties to a suit as to the object of that suit, while they are also entitled to, get this, very high respect and consideration in all parallel cases by other departments of government. Pause again. Got this? Did you hear that? What are these cases, these decisions of courts entitled to? Very high consideration and respect by the other branches of government. Notice the gap between very high consideration and respect and to be obeyed by other branches of government. Lincoln refuses to concede it. In fact, he asserts the opposite proposition, that the other branches must interpret the Constitution for themselves, and there may very well be circumstances in which they, by virtue of their own obligations under the Constitution, must resist treating the decisions of a court as a binding rule. But Lincoln goes on. And while it is obviously possible that such decision may be erroneous in any given case, that's the decision of the court in any given case, still the evil effect of following it, that is, treating the case as binding on the parties in the case, being limited to that particular case, with the chance that it may be overruled and never become a precedent for other cases, can better be borne than could the evils of a different practice. At the same time, Lincoln goes on, the candid citizen must confess that if the policy of the government upon vital questions affecting the whole people is to be irrevocably fixed by decisions of the Supreme Court the instant they are made in ordinary litigation between parties in personal actions, the people will have ceased to be their own rulers, having to that extent practically resigned their government into the hands of that eminent tribunal, unquote. For Lincoln, then, the evil of the Dred Scott decision was not merely the expansion of slavery. It was that the decision threatened to undermine the basic principles of Republican government precisely by establishing judicial supremacy in matters of constitutional interpretation. It was not merely that the court decided the suit in favor of the wrong party, though Lincoln certainly thought that it did that. It was that the court claimed authority to decide for the other branches once and for all what the Constitution required, thus placing them in a position of inferiority and subservience. For the people to resign their government into the hands of that eminent tribunal would be, according to Lincoln, to abandon Republican government itself and acquiesce in what Jefferson called oligarchic despotism. There's not a very faint, there is a not very faint echo of Jefferson in Lincoln's first inaugural address. In office, Lincoln gave effect to his position against judicial supremacy by consistently refusing to treat the Dred Scott decision as creating a rule of law binding on the executive branch. His administration issued passports and other documents to free blacks, thus treating them as citizens of the United States, despite the court's denial of their status as citizens or the possibility of them being citizens. He signed legislation that plainly placed restrictions on slavery in the Western territories in direct defiance of Taney's ruling. Now, the question is, was Lincoln right to reject judicial supremacy? The issue is profoundly important, but the question is seldom asked today. And what's worse, so many of our students don't know to ask it. I mean, they're surprised when it's asked. And they find the discussion of it actually quite exhilarating, if somewhat disturbing, for reasons I'll go into in a few minutes. But it's not being asked, certainly not being asked often enough. And if people don't know to ask it, then we've got a problem, and the problem's got to be fixed. Lincoln's critics at the time condemned him for his defiance of the Supreme Court. It wasn't as though there were not defenders of judicial supremacy in Lincoln's time. There was a lively argument with Lincoln at the center of it. His critics said that his actions, combined particularly with his suspension of the writ of habeas corpus, were lawless and even tyrannical. I'm sure those of you who have done your U.S. history will remember Lincoln's Democratic critics calling him a tyrant. And of course, there's the unresolved question if, in fact, that's not what John Wilkes Booth said when he jumped from the booth onto the stage, and sic semper tyrannis, thus made ever to tyrants. Well, few today, of course, make these charges against the great emancipator. He's considered one of the great, rightly in my view, one of the great heroes of the American political regime and American political history. Yet, almost everybody accepts uncritically, without questioning, the doctrine of judicial supremacy that Lincoln not only denied, but most emphatically defied. I find that my own students are more than a little surprised to learn about the views of Jefferson and Lincoln. They, too, have drunk in the idea that courts, particularly the Supreme Court, upon which more than a few of my students imagine themselves someday serving, are the ultimate protectors of rights, and as such should have the ultimate say, should have it, in constitutional questions. After all, they reason, somebody or some institution has to have the final word, or else nothing is ever settled. And students, at least my students, want things to be settled. And the ultimate settler of things, when the things in question are politically ultimate things, constitutional things, should be, they tell me, a non-political body. That's what they want. They want these fundamental questions to be resolved by a party or a body, an entity that is immunized from politics, that's not in politics, that's not susceptible to political pressures and so forth. Politics is too messy. Democratic institutions are too prone to passion, prejudice, demagoguery, foolishness, for us to entrust to them matters of constitutional significance. We don't want to make our rights subject to voting, students tell me. There needs to be a higher institution, they say, to provide a check against the bigots and demagogues of politics. An institution where matters are resolved by calm and rational inquiry and judgment. An institution whose membership is drawn from a narrower, more refined, more highly educated circle. One that is not subject to political retaliation for unpopular decisions of principle protecting people's rights. What would have happened, they ask, had the political branches felt themselves to be free to dispute Brown versus Board of Education? Now, one imagines Lincoln in the classroom reminding students that the unchecked power to do good is unavoidably the unchecked power to do evil. If we like what the justices did in Brown versus Board, and we do, let us not forget what they did in Dred Scott. And there's more to the balance sheet. Was it not the court, after all, that during the period from 1905 to 1937 repeatedly invalidated both state and federal worker protection laws and social welfare legislation? Did they not read into the Due Process Clause of the 14th Amendment a right to freedom of contract in whose name they frustrated the legislative will and usurped the constitutional authority of the elected representatives of the people who sought to prevent the exploitation of workers? This, in any event, is the conventional reading of the history, and it's a reading shared by conservatives and liberals alike. And then there's the issue of abortion, surely the most vexing and divisive morally charged issue of our own time, the one that won't go away. Does the Supreme Court's ruling striking down state prohibitions of abortion in the 1973 cases of Roe versus Wade and Doe versus Bolton belong on the plus side of the court's ledger with Brown versus Board, or on the minus side with Dred Scott? Does that, in turn, depend on whether one happens to think, as a moral matter, that abortion is a woman's right, or one happens to think that it's a violation of the rights of the unborn child? If so, should one's view of the proper scope of judicial power and the legitimacy of judicial supremacy depend upon the contingent fact, and after all it's merely contingent fact, that the court happened to come down the way it did on the abortion question? After all, the court could have come down, as the German Constitutional Court did come down in a 1975 decision interpreting Germany's basic law, in precisely the opposite way, invalidating a legislatively enacted liberalization of abortion. Supporters of the right to abortion who criticize the German decision make exactly the same arguments, the same Lincolnian arguments, against judicial supremacy that supporters of the right to life who criticize Roe versus Wade make in the United States. Their argument is, to put it in Lincoln's language, that if the policy of the government upon vital questions affecting the whole people is to be irrevocably fixed by decisions of the Supreme Court, the people will have ceased to be their own rulers. Now, the question of who, if anyone, or any branch of government has supreme authority to interpret the Constitution is one important issue. Another, and an obviously closely related one, is the question of how we ought to understand the Constitution and its role and function. Is ours a so-called living Constitution, whose words, actual words, matter little? On the living Constitution theories, and there are various variants of it, of course, judges, especially Supreme Court justices, serve as members of a kind of standing constitutional convention whose role is to invalidate legislation that is regarded as antiquated or retrograde, all in the name of adapting the Constitution to keep it up with the times, to keep it living. Now, this is a seductive idea, or bit of rhetoric, but it is, in my view, a very bad one. The purpose of enshrining principles in a Constitution is to ensure that the nation's fundamental values remain honored even if they fall out of fashion. As for adapting the nation's laws to keep up with the times, legislators can and should take care of that task. The proper role of courts when they exercise the power of judicial review is essentially a conserving, one might even say a conservative one. It's not to change anything, but rather to enforce constitutional limits on what can be changed by ordinary legislation. Now, does this mean that the Constitution is dead? If you reject the theory of a living Constitution, does that commit you to the theory that the Constitution is dead? Well, no. The Constitution's principles are very much alive. They are living in the sense that they can apply validly today, just as they did then, and can even apply to problems that the founders themselves could not have anticipated or imagined. The original understanding of Fourth Amendment principles governing searches and seizures, for example, can be extended to cover today's controversies about computer files, cyber storage, and electronic surveillance. So to reject, as I think we should, the living Constitution theory and its doctrine of what amounts to virtually unlimited judicial power, is by no means to treat our Constitution as a dead letter. Rather, it's to treat the Constitution as law, supreme law, binding on and limiting the power of every branch and agency of government, including the courts. The source of weakness with civic education today, in my opinion, is not with students. They're bright and eager to learn, particularly eager to learn, and not just my own students at Princeton. I lecture a lot around the country, and everywhere I go I find that students are very eager to engage issues about the nature of American political thought, the nature of the political philosophy of the founders. It seems to me that our problem is that too few teachers are presenting students with the founders' philosophy, much less introducing them to the great issues, some still with us today, that divided the founders. And if teachers aren't teaching founding principles, where will students learn them? They're not likely to get any sense of the distinction between, say, the delegated powers of the national government and the general jurisdiction of the states from reading newspapers, even good quality newspapers, or national magazines, or from television news shows. In my view, if the job is not done in the classroom, it won't be done. It's the kind of work that really requires reading, and really requires thinking, and really requires debate, discussion, maybe even a little lecturing on the part of a professor, to start to really get a grip on the political science of the American founding. So the solution, though obviously not easy, is straightforward. We need to make a commitment at every level of schooling, including colleges and universities, within the public media to the extent possible, to promote a deep awareness of the principles of the American founding, and to invite our students into the great debates so that they not only understand that there was a difference between Jefferson and Hamilton on some very important questions, but also that that's an issue that they should themselves try to understand with a view to forming an opinion about, to understand as a live issue. And the same, obviously, with the question of judicial supremacy. Students should have a position on the judicial, all citizens should have a position on the judicial supremacy question. But in my view, a person's really only entitled to have a position if they understand what the arguments are for the one side and what the arguments are for the other side. And they stop and they think and they reflect and they consider whether the arguments on the one side are stronger than the arguments on the other. Great minds have come down on both sides. People of reason and goodwill can come out either way. Much care in the end whether they agree with me or not. I do care that they adopt a position and that they adopt it on the basis of reflection that includes consideration of the best arguments to be made on the competing sides. And there's just no place like the classroom for that to happen. You know, even the good work that's done by a show like the Lehrer NewsHour, where experts are brought on and people are given a bit of time and it's not just sound bites. There's not enough time. The context isn't just right. I mean, it cannot replace what needs to be done in the classroom. Now, someone might ask, why educate students into archaism? Surely governing principles set forth in the 18th century have little relevance to us in the 21st. Well, my answer to that reveals some views I hold that are undoubtedly controversial. My answer to that is American ideals, as embodied preeminently in the Declaration of Independence, are universal and timeless. They're not archaisms. They have force wherever there are human beings, fallible, indeed, as the founders recognized, fallen. You might read the 10th Federalist paper to see just what at least one very important American founder thought we human beings were like. Fallen creatures, yet, nonetheless, images of God in our possession of reason and freedom. Beings, as the Declaration says, endowed by their Creator with certain unalienable rights. The constitutional scheme that the founders devised for the lawful governance of human beings and for the preservation of their sacred rights is, in my opinion, the world's greatest achievement of practical political science. Of course, we shouldn't treat our institutions as if they're perfect. The founders provided, after all, for their possible revision by constitutional amendment, either because there was an inherent flaw in them and need for change on greater reflection, or because an adaptation to changes in the times was required. In any event, true civic education must never be indoctrination. It's not important whether the students share the particular professor's view, whether in favor of Lincoln or against him on the judicial supremacy question. As I said before, what's important is the student has thought about the question, considered the best arguments to be made on the competing sides. The founders themselves were not of one mind as to the proper interpretation of their handiwork in every respect. And reasonable people of goodwill, of course, disagree about key matters of constitutional interpretation. We do our students a wonderful service when we invite them into the great debates about the meaning of our fundamental law in controversial cases, such as Lincoln's debate with his critics over judicial supremacy. To do that, though, we must equip them with the historical knowledge and the philosophical understanding necessary if they are to evaluate intelligently the competing arguments. You know, very often when serious people who want to improve the quality of civic education hear about the surveys in which students can't identify the century the Civil War was fought in or can't tell you whether Lee surrendered to Grant or Eisenhower, they say, oh, we've got to do something about this. The answer is we've got to improve the teaching of American history. And that's true. It's important. We do have to improve the teaching of American history. But it's not just history. If students are going to be participants in these debates into which we need to invite them, they need to develop the philosophical acumen to be intelligent participants in that debate. It's not just a knowledge of the historical facts. Now, we needn't teach that our institutions are uniquely just, or that any polity that seeks to respect people's rights and preserve liberties must copy these institutions precisely. That's not true. But anyone who sincerely seeks the truth will see, I believe, that ours are indeed worthy institutions that have served Americans well whenever our people and our leaders have shown the wisdom and mustered the fortitude to honor and live by them. The fact is that freedom-loving people throughout the world, even in an age darkened by widespread anti-Americanism, draw inspiration from American ideals and look to American institutions as the gold standard of Republican government. The students in the room, I think, at this point are probably too young to remember, but the faculty and others my age in the room will very vividly remember the Chinese students assembling in Tiananmen Square, where they erected what? A copy of the Statue of Liberty, and where they read from what? The Declaration of Independence. Even critics of American policy feel they must pay at least lip service to our ideals of democracy, limited government, equality before the law, civil liberty, private property, the free economy, and the rule of law. Madison himself did not doubt that it would be so. Here's what he said. He said, "The free system of government we have established is so congenial with reason, with common sense, and with a universal feeling that it must produce approbation and a desire of imitation as avenues may be found for truth to the knowledge of nations." In Eastern Europe, much of Latin America, and parts of South Asia and Africa, avenues have been found for truth to the knowledge of nations, and republican forms of government have spread. Not always without backsliding, as we now see in parts of Latin America. But whether progress toward authentic republican government in the Middle East can be made is yet to be seen. And one of the most important debates in our own country today is whether the conditions for democracy exist in places like Iraq and Lebanon, and if so, what role, if any, the United States and other democratic powers can play in fostering democratic institutions. Understandably and probably inevitably, the debate has gotten bound up with disagreements about U.S. policy in Iraq and the Bush administration's decision to remove Saddam Hussein by military force and then try to establish a democratic regime that would be regarded as legitimate by the competing Kurdish, Sunni, and Shia factions. Bush administration critics raised questions of the constitutionality of the president's actions in Iraq and at home, especially at home when it comes to wiretapping and other forms of surveillance, the treatment of detainees, military tribunals, and the like. These are important questions, and their urgency highlights our need for improved civic education if our citizens are to debate them intelligently and reach sound conclusions. Madison famously observed that, quote, "only a well-educated people can be permanently a free people," unquote. Yet some today, I've learned, think otherwise. They don't necessarily doubt that the impoverishment of civic education or civic understanding erodes citizenship and statesmanship, but they wonder why we can't get along perfectly well anyway. We are, after all, the richest, most powerful nation in world history. We're on top, and despite the emerging challenges from China and perhaps from India, we'll likely be there for quite some time to come. Isn't that enough? This was a reaction I was somewhat surprised to give when I gave a talk on civic education to a group of very prominent businessmen in New York. And one raised his hand and said, well, sure, it's bad that people don't know which century the Civil War was fought in, but why does that matter? We're on top here. We've got the military power. We've got the economic power. We're going to get along just fine. Well, history shows us that basic freedoms are hard-won and easily lost. The institutions that preserve freedom can be crumbling even as they appear strong. Severe economic strains and other fundamental challenges can tempt people to compromise or sacrifice even basic freedoms. This is what critics of our current policies on wiretapping and the treatment of detainees are concerned about. Now, whether their specific positions on questions such as the scope of executive power and the rights of detainees are correct or incorrect, their concerns are plainly legitimate. No one today is arguing for the expulsion or internment of Arabs or Arab Americans as possible security risks, but it's worth remembering that during the Second World War, Franklin Roosevelt and the New Deal Congress, at the urging of then-Governor Earl Warren of California, interned thousands of Japanese Americans in camps in Oklahoma and elsewhere, taking their property and depriving them of basic civil liberties. When FDR's actions were challenged in constitutional litigation, they were upheld by a majority that included such noted civil libertarians as William O. Douglas, Hugo Black, and Felix Frankfurter. Justice Stephen Breyer recently mentioned to me something I didn't know, that the internment of Japanese Americans was in fact opposed by one very prominent American official at the time, FBI Director J. Edgar Hoover. Hoover said that there was no evidence that the internees were security risks. As James Madison knew, it is conviction born of knowledge, in other words, it's civic understanding, that is our true bulwark, our only true security in the face of such temptations. And as Plato, though he is no admirer of democracy, observed, the goal of the polis, the political order, isn't merely to establish security, as important as that is, but also to provide the conditions for citizens to live good and decent lives, lives worthy of human beings as rational and moral creatures. Our founders saw this critical philosophical point. The purpose of the Declaration of Independence and its principles of civic life, Jefferson wrote shortly before he died, were, quote, not to find new principles or new arguments never before thought of, nor merely to say things which had never been said before, but to place before mankind the common sense of the subject. All its authority rests on the harmonizing sentiments of the day, whether expressed in conversation, in letters, printed essays, or in the elementary books of public right, such as Aristotle, Cicero, Locke, and Sidney, unquote. These elementary books inform us that statesmanship, and especially citizenship, though key means to other ends, of course, possess a value greater than merely instrumental. When we carry out our civic responsibilities in an informed way, especially, I believe, this is true of democratic citizens, we find ourselves ennobled as individuals and as a community. Even if a nation really could remain on top in the global competition for military and economic standing or superiority, and even if its basic political structure could last more or less indefinitely, it seems to me that the people of that nation, if they remain ignorant of the moral foundations of that structure, would be impoverished. Whatever one thinks of the decision to invade Iraq, one cannot fail to find deeply moving, at least I cannot fail to find deeply moving, the desire of so many Iraqis, and now we see it with Iranian citizens as well, to be democratic citizens, a desire that cannot be accounted for merely by noting the tendency of democracies over time to be prosperous and stable. Rather, those Iraqis proudly displaying their ink-stained fingers after voting were saying something that we Americans at some level still appreciate, that democratic citizenship fulfills an important aspect of our humanity. It is so inherently desirable that Iraqi men and women were willing to risk their lives to exercise the franchise, just as it caused those 18th century Americans who pledged their lives and fortunes and sacred honor to risk the king's hangman's noose. So our posture must not be complacent. The reform and renewal of civic education in our nation truly is a noble cause. We must make it an urgent priority. Thank you. Thank you. Q&A?
Some time for discussion.
Absolutely.